Welcome back. In my last video, Tom Hartman and I told the story of the Santa Clara case up through May 10th, 1886, when the Supreme Court handed down its decision. If it had been any other case, that would have been the end of the story. But thanks to the fact that Chief Justice Waite made a strange out-of-place comment literally seconds before the decision was read by Justice Harlan, it was not the end of the story. That's because the court reporter in the case, J.C. Bancroft Davis, was not just a court reporter. Davis was also the reporter of decisions of the Supreme Court, whose headnote summary was printed in the law books published by Banks and Brothers Publishers in New York. It's crucial to understand that literally anybody else writing that headnote summary would have based it on the court's decision and would have written something like this. Santa Clara County, California sued the railroad for taxes it claimed were owed. As one of several defense arguments, the railroad claimed improper tax assessment of fencing along its right-of-way based upon calculations by the state of California. The court found that the state was not the legitimate taxing authority and unanimously ruled in favor of the railroad, declaring the county's tax assessment on the fencing null and void. That would have been a perfectly accurate, in a nutshell, summary of the Santa Clara case that would have been useful for any judge or lawyer looking through the law books, trying to find a case similar to the one that they were working on. It's crucial to understand that no other writer in the world would likely have even mentioned the 14th Amendment issue in his summary of the case, which, by the way, is printed in large type right at the beginning, so that a lawyer or judge looking through the books will quickly be able to see what the case was about. Because the constitutional issue, the 14th Amendment issue, was mentioned in the court's decision, formerly known as the court's opinion, any other writer about halfway through the couple dozen paragraph long summary of the decision would have written something like, Southern Pacific, joined by other railroads, argued that the 14th Amendment included corporate persons under its protection. As these arguments were not necessary in deciding the case, the court did not consider them. What's interesting is that J.C., in writing his own summary of the court's ruling, his summary of the court's opinion, wrote something pretty similar to this. He said, quote, "The main and almost only questions discussed by counsel in the elaborate arguments related to the constitutionality of the taxes. The court, in its opinion, passed by these questions," meaning that the court did not even consider them. What's even more interesting, though, is what J.C. said in the headnote summary of the case, printed in large type right at the beginning. Instead of saying that the case was about taxes on fencing and the court ruled in favor of the railroad because the taxing method used by the county was invalid, J.C. Bancroft Davis said something different. Mr. Hartman mentions that he did not find this on the Supreme Court's official website. It just wasn't there. He found this and photocopied it from volume 118 of the official record of the Supreme Court, published by Banks and Brothers. What J.C. Bancroft Davis actually said in the very first sentence of his headnote to the Santa Clara case was, quote, "The defendant corporations are persons within the intent of the clause in Section 1 of the 14th Amendment to the Constitution of the United States, which forbids a state to deny to any person within its jurisdiction the equal protection of the laws." End quote. I think it's important to mention that Tom Hartman does not come right out and call J.C. Bancroft Davis a liar. That's because true nerd style, Mr. Hartman only states the facts and then allows his beloved readers to reach their own conclusions. I've reached a conclusion that JC was in fact a liar who knew that what he was saying was a lie based upon something he said about 3/4 of the way through his summary of the court's ruling. 2 paragraphs after he said that the court had passed by on the constitutional questions, JC wrote, before argument, Mr. Chief Justice Waite said, and then he wrote almost verbatim, almost word for word, what Chief Justice Waite had said in his off-the-wall comment seconds before Justice Harlan read the actual decision. Only one word is different. Having established way beyond a reasonable doubt that Chief Justice Waite made his off-the-wall comment just to get it into the court record so that J.C. Bancroft Davis could later take that comment way out of context and make it part of the court's ruling, it's still kind of a mystery how this wording morphed into the much more definite and specific wording that he used in the very first sentence of his headnote, which was printed in larger type in the law books. Well, Mr. Hartman demystifies that by introducing us to another justice on the Supreme Court at the time, a man by the name of Stephen J. Field. This guy was a real piece of work. He was an appeals court judge in California at the same time as he was serving as an associate justice on the Supreme Court. Clearly those jobs were beneath someone as exceedingly superior to everyone else as Field. Since no emperor of the universe position existed, he thought that he should at least be president. Although I am being a little sarcastic here, from what Mr. Hartman says about him, that's probably a pretty accurate description. Mr. Hartman says that Field had presidential ambitions and was relying on the railroads to help him. He had publicly announced that as president, he would increase the size of the Supreme Court and pack it with able and conservative men. No doubt corporatist a-holes like himself. Mr. Hartman adds that Field was often described as a popinjay, a vain, conceited person who liked to strut around talking down to people. The thing is, as an appeals court judge in California, Field had often ruled that corporations had the same rights as people under the 14th Amendment. And the wording of his rulings in those cases curiously matched the wording in the headnote of the Santa Clara case. Coincidence? After recording the last shot, I took a break for lunch. That was 2 days ago. Because after I woke up from my nap, instead of coming back here to my mudroom to complete this video, I stayed on my couch because I wanted to go online and do a little research. Tom Hartman would be so proud of me. First thing I wanted to do is go to the Supreme Court website, because Mr. Hartman said he found the Santa Clara case there, but missing JC's headnote. Well, I couldn't even find cases back that far. So I did some more searching on the internet and eventually found it at the Library of Congress in PDF format. I don't know how to do clickable links, but I took a screenshot of the web address that I'll put down here somewhere so that you can type it into your browser and look it up if you want. It is a PDF, so you'll have to scroll down until you find the case. The important thing is I took a screenshot of the beginning of the Santa Clara case. The formatting is weird. I don't know why. It's not like Mr. Hartman describes in his book. The important thing is it does show the monumental lie that J.C. Bancroft Davis stated as the first sentence of his headnote in the Santa Clara case. A couple of other things. I was confused about other railroads joining the Southern Pacific in their defense. Chief Justice Waite actually combined 3 different cases involving just 2 railroads and heard all 3 cases at the same time. The phrase error 2 just means that the Supreme Court's decision was against the lower courts. If the Supreme Court's decision agreed, then it would say upholds or affirms the lower court decision. One last thing is that this says that the cases were argued in January of 1886. Mr. Hartman says 1885. I don't know which is correct, but because Wikipedia says 1886, I suspect that Mr. Hartman is correct. Never trust anything on Wikipedia having to do with politics or economics. I didn't go any deeper into this, just took the screenshot and moved on, because I wanted to research some facts that support Mr. Hartman's theory of how this abomination became law of the land as if it had been written into our Constitution itself. I also wanted to confirm or not a couple ideas that I had. Well, what I found was interesting and informationful. And if I tried to stuff it all into this video, it would be way too long. So I'm just going to pick it up here in my next video, which I think will be vid 13. Hope you join me. If you like this video, why not click the like button? I'll put a link to the next episode over here.